This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why an insured cannot assign a bad faith claim because it is not a contractual right but a extra contractual right, and why an insured may, however, intervene to assert a bad faith claim that was not assigned. The judge in this case required a conflict between different district courts in Louisiana to be resolved on appeal. And therefore, in Allstate Construction Company Incorporated versus Ohio Security Insurance Company, the United States District Court for the Middle District of Louisiana on September 30, 2025, dealt with Vina Cleaners, the insured who assigned its claim against Ohio Security to Allstate Construction, but did not assign its rights to sue for the tort of bad faith. So Vina Cleaners intervened in the Allstate Construction suit to allege its rights to bad faith damages. In an insurance dispute following damage caused by Hurricane Ida to Vina Cleaners' property, Vina Cleaners had been insured under a commercial policy with the defendant, Ohio Security. Vina Cleaners assigned its rights under the policy to Allstate Construction, which then filed suit against the insurer for breach of contract and bad faith. The court dismissed the bad faith allegations since it was not assigned to Allstate, and then Vina Cleaners moved to intervene. The main legal issue revolves around whether Vina Cleaners can assert bad faith claims under the Louisiana bad faith statutes after assigning its rights to Allstate Construction. The court was required to decide if the assignment of rights included the right to pursue bad faith penalties, which are considered extra contractual. The USDC noted that there is a conflict between different district courts in Louisiana regarding the interpretation of these statutes and these assignments. The court dismissed Allstate Construction's bad faith claims against the insurer, reasoning that Allstate Construction's bad faith claims were extra contractual and the assignment of rights between Vina Cleaners and Allstate did not expressly include an assignment of claims under the Louisiana statutes allowing for bad faith claims. Vina Cleaners, as an intervener, sought to assert the same bad faith claims against the insurer. The court noted that in a case entitled Creamer Brothers, Inc. versus General Casualty of Wisconsin, the Western District of Louisiana on September 12, 2024, held that an assignor that assigned its rights under an insurance policy did not assign its bad faith claims because the assignment was not sufficiently expressed. Thus, the Western District held that the assignor retained its rights to bring bad faith claims against the insurer. Vina Cleaners asked the court to follow the Western District's decision in Creamer Brothers and reject an interpretation that it would allow insurers to evade accountability for bad faith conduct solely because the insured exercised its right to assign policy benefits. The district court found that there's a conflict between the Louisiana Federal District Court's interpretation of Louisiana law on this issue, and this is an important issue for both parties. If the court grants defendant's motion, the result is that no party holds the right to assert bad faith claims against the defendant. If the court denies defendant's motion, defendant faces steep penalties under Louisiana's bad faith statutes when it is unclear whether the result is legally sound. Since the issue involving Allstate Construction and the same counsel for Allstate Construction is presently on appeal, the U.S. District Court decided to not decide and denied defendant's motion to dismiss Vina Cleaners' complaint and intervention without prejudice, hoping that the appellate court resolves the dispute between the district courts and that the motion can be renewed depending on how the appellate court rules. In my opinion, the tort of bad faith is extra-contractual and therefore cannot be assigned, as an insured can assign any rights it has against an insurer under the contract. Allstate Construction tried to get tort damages from the court based on its assignment for Vina Cleaners and lost. Vina then moved to intervene in the suit to get the tort damages allowed by Louisiana statutes, even though it had given away its contract rights to Allstate Construction. The court, faced with different interpretations and a pending appeal, the court punted and, by ruling without prejudice, let the parties litigate, but keep the motion to intervene subject to dismissal after the appellate court rules. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week. And you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog and the videos and let them subscribe to the blog and videos. And if you're watching this video, please click on the like button if you're watching on YouTube, or the thumbs up button if you're watching on rumble.com. If you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.